If you're facing a harassment charge in Arizona, it can feel like you're trying to navigate a maze in the dark. The legal language is tricky, the stakes are high, and it's just overwhelming. So today, we're going to shed some light on it. We're going to break down exactly what ARS 13-2921, that's Arizona's harassment law, really means, piece by piece.
But hold on, before we go any further, we have to be crystal clear about something. This is for your information, for educational purposes only. This is not legal advice. If you are actually facing charges, the very first thing you should do is talk to an experienced criminal defense lawyer in Arizona. Seriously.
All right, so here's our game plan. We're going to tackle this in 5 parts. We'll start with the basic definition, then look at what actions actually count as harassment. After that, we'll get into the penalties, clear up the confusion between harassment and stalking, and finish up with the all-important legal deadlines.
So let's start at square one. What exactly is harassment in the eyes of Arizona law? It's a lot more specific than you might think. Okay, the legal definition basically has a 2-part test. First, the behavior has to be something that would make a reasonable person feel seriously alarmed or annoyed. And second, it has to actually make the target of the behavior feel that way. So it's not just about what you did, it's also about the real-world impact it had.
And that brings up this fascinating idea of the reasonable person. So who is this person? Well, the law isn't talking about someone who is super sensitive and gets upset by everything. And it's also not talking about someone who's so tough that nothing bothers them. The question is, would an average, everyday person find this behavior seriously disturbing? It's a way to keep things balanced.
Now, this next point is absolutely crucial, so lean in for this. To get a conviction, the prosecutor has to prove one of 2 things about your mindset. Intentional is easy. You meant to do it. Your goal was to harass them. But there's also knowing. This one's broader. It just means you were aware of what you were doing. Like, you knew you were sending the texts or making the calls. You didn't have to know it was illegal. You just had to know you were doing it. And they only need to prove one of these, not both.
Okay, so now that we have the legal definition down, let's get practical. What kinds of actions actually cross that line and become criminal harassment?
Well, the law points to a few main categories. You've got things like repeatedly following someone or keeping them under surveillance. Another big one is making false reports to the police or other authorities just to cause them grief. And probably the most common is unwanted communication. We're talking endless calls, texts, emails, you name it, that goes beyond a simple annoyance into something truly alarming.
But it's also really important to know what isn't harassment. The law specifically carves out protections for things like legal protests and picketing. It also makes exceptions for people who are just doing their job, like licensed PIs or process servers delivering court papers.
All right, we know what it is and what it isn't. Now let's talk about the consequences. Because honestly, a conviction can change your life.
And this chart just lays it all out. A standard harassment charge is a Class 1 misdemeanor. That can mean up to 6 months behind bars and 3 years of probation. But look what happens if the target is a public official. The charge jumps all the way up to a Class 5 felony. Now you're looking at a potential 2.5 years in prison. That is a massive leap.
And the penalties can get even steeper. The law has this concept called aggravated harassment. Think of it as harassment on steroids. It's when the situation has certain factors that make the crime much more serious, and yeah, it comes with way tougher felony penalties.
So what turns regular harassment into aggravated harassment? There are 3 main triggers. 1, if you do it while violating a protective order. 2, if you have a past domestic violence conviction against the very same person. Or 3, if you were out on release for another charge and this was a violation of your conditions. Basically, the law sees these as signs of a dangerous pattern or a blatant disregard for the court.
This brings us to a really important distinction that a lot of people get mixed up: harassment versus stalking. People throw these words around like they're the same thing, but legally, they're not even close.
Here's the difference in a nutshell. Harassment, like we've been saying, is about causing serious annoyance or distress. Stalking, which is a whole different law, adds a key ingredient: fear. Stalking is conduct that makes a person afraid that they'll be physically hurt or that their property will be damaged. That element of fear is the legal line in the sand.
Okay, for our final topic, let's talk about the clock. In any criminal case, there's a deadline for the government to file charges. It's called the statute of limitations.
To put it simply, the statute of limitations is a countdown timer. The prosecution has a set amount of time after an alleged crime to bring a case. If they miss that window, that's usually it. The case can't move forward.
So for a typical harassment case, the ones that are charged as misdemeanors, that timer is set to 1 year. From the day the incident supposedly happened, prosecutors have 365 days to file.
But remember those felony charges we talked about for harassing a public official or for aggravated harassment? In those cases, the timeline gets stretched way out. For serious felonies like those, the state has a full 7 years to file charges.
So let's wrap this all up. What are the absolute key takeaways here? First, harassment is judged by what a reasonable person would think. Second, it has to be done either intentionally or knowingly. Third, it often involves following false reports or unwanted messages. Fourth, the penalties get really serious really fast for aggravated cases. And finally, remember the clock. Prosecutors have 1 year for misdemeanors, but 7 years for felonies.
Look, the law provides a blueprint, but every single case is built differently. The specific facts and details of your situation are everything. And that's why I'll say it one last time. If you're trying to figure this out for yourself, the most critical step you can take is to talk to an experienced lawyer who knows how to apply these laws to your unique circumstances.